Imagine pouring like millions of dollars into perfectly curing this massive concrete foundation. You're rigorously testing the compressive strength, signing off on all the rebar inspections, only to look up and realize you built the entire structure on the wrong continent.
Yeah, that's a nightmare scenario.
Right. But
Yeah.
that is essentially what happens when a seasoned construction professional walks into an international arbitration room and, well, relies entirely on project site logic.
Oh, absolutely.
Like, they just completely ignore the legal and procedural strategy that actually dictates the outcome. You could have the most perfect technical case, but if you build it in the wrong jurisdiction...
Or use the wrong procedural materials. Yeah.
Exactly. It will just collapse under its own weight.
It is a brutal realization for a lot of people because, on a project site, reality is dictated by physics, right? Engineering tolerances, visible progress.
Yeah, you can actually see the work.
Exactly. You can literally point to a cured concrete slab and say, well, there it is, the work is done. But the second you step away from the physical site and cross the threshold into formal dispute resolution, that tangible reality is entirely replaced.
Replaced by what, exactly?
By a construct made of contractual interpretation, evidentiary burdens, and highly rigid procedural frameworks. Basically, the rules of physics are replaced by the rules of arbitration.
Wow. Okay, so welcome to today's deep dive. And if you are listening to this, you are likely someone who lives in that world, the world of physical and financial project execution.
Right. The quantity surveyors, the contract engineers.
The commercial managers, the project controls directors, all of you. Our mission today is highly specific. We are taking a really comprehensive stack of source materials covering international construction arbitration, and we're going to extract the precise mechanics you need to transition your mindset.
Which is a huge shift.
It really is. We are charting the evolution from being an absolute master of the project site to becoming a formidable, highly effective architect of a winning arbitration case.
And, to make that transition, we have to dismantle a really dangerous misconception. Arbitration is frequently framed as this esoteric, purely legal arena.
Like it's just for the lawyers.
Right. Reserved exclusively for barristers, senior partners, professional arbitrators, just debating obscure 19th century case law.
Yeah, that's the stereotype.
But that is fundamentally incorrect when it comes to construction. A major multi-million-dollar construction arbitration is rarely won on a purely abstract legal argument.
So what wins it then?
It's won through a rigorous, unassailable synthesis of factual project records, complex delay and quantum analysis, and basically a total mastery of the contract machinery.
And looking at the materials, the lawyers don't actually have that deep project knowledge, right?
Yeah.
You do. The commercial and engineering teams are the ones who understand how an underground water ingress event actually impacts a tunnel boring machine.
Precisely. They're the ones in the dirt.
Yeah. But the massive shift we have to achieve today is changing how that project knowledge is communicated. You cannot walk into a tribunal with the project site mentality of saying, look, we all know the employer delayed us because they kept changing the design.
No, that statement is absolutely worthless in arbitration.
Worthless? Really?
Actually, it's worse than worthless. It damages your credibility. A tribunal does not care what you believe.
Wow, okay.
The shift is moving from, this is what I know happened, to this is what the contemporaneous records objectively establish.
Right. It's all about the records.
Exactly. And then taking the crucial final step, which is this is the precise contractual entitlement and financial consequence that flows from what those records establish. You're not abandoning your engineering expertise, you're weaponizing it.
Weaponizing it by learning the procedural language of the tribunal. I love that. So to make this transition tangible, we are going to weave a hypothetical high-stakes case study throughout this entire deep dive.
That's a great idea.
Let's call it the Meridian International Airport expansion. It's a massive $2 billion infrastructure mega project. You, the listener, you are the commercial director for the main contractor.
Sounds stressful already.
Right. You are building a state-of-the-art terminal and a complex underground automated baggage handling system. But things have gone terribly wrong.
As they often do.
Yeah, delays are stacking up, costs are spiraling, and the relationship with the employer has just completely broken down.
A very familiar scenario in international mega projects, unfortunately.
I bet.
The project correspondence has devolved into aggressive letters, payment certificates are being withheld, and both sides are, threatening termination. Basically, you're preparing for war.
Right. But before we even start talking about delay models or calculating the standby costs for your equipment, We have to recognize the most fundamental reality of the dispute landscape.
The foundation.
Exactly. You cannot argue your brilliant technical case regarding the baggage handling delays if you don't legally have the right to stand in front of the arbitrators in the first place.
You have to be allowed in the room.
Yeah. Everything flows from a single foundational document, which is the arbitration agreement.
This is the blueprint. I mean, arbitration is entirely a creature of consent.
Consent? How so?
Well, unlike national courts, where a judge has this innate state-granted jurisdiction over parties in their territory, an arbitral tribunal has zero innate power.
Oh, interesting.
Their authority exists solely because the contractor and the employer voluntarily sign a contract agreeing to take their disputes out of the public court system and, submit them to a private tribunal. If that agreement is flawed, the tribunal's power is instantly nullified.
Okay, looking at the standard contracts, these dispute resolution clauses are usually buried at the very back of the general conditions, right?
Yeah, usually clause 20 in a standard FIDI contract.
Right. And during the tender phase, commercial teams are aggressively negotiating the variation percentages, the advance payment bonds, the delay damages. Nobody is paying attention to the boilerplate dispute language.
Nobody ever does.
So what specifically does a construction professional actually need to analyze in this clause once a dispute crystallizes?
You have to dissect the operational mechanics it triggers. So first, what is the exact scope of the disputes covered?
The scope, like what they're allowed to argue about.
Exactly. Does the clause say, any and all disputes, controversies, or claims arising out of or relating to this contract shall be referred to arbitration?
That sounds pretty standard.
It is. That's a broad, healthy clause. But does it contain narrow carve-outs? Perhaps stating that disputes regarding the valuation of variations shall be determined by the engineer, whose decision is final.
Ah, so it boxes you out.
Right. If you have a narrow clause and you try to arbitrate a variation valuation, the tribunal will just throw the case out.
Because they physically don't have the contractual mandate to hear it. The parties literally didn't consent to arbitrate that specific issue.
Exactly.
What about the rules of the game? I see the sources heavily contrast institutional arbitration with ad hoc arbitration.
This is a critical distinction for the commercial team projecting the budget and timeline of the dispute.
Okay, lay it out for us.
So institutional arbitration means the clause specifies a major administrative body, like the International Chamber of Commerce, the ICC, or maybe the London Court of International Arbitration, the LCIA.
Right. So what do they actually do?
These institutions provide a robust set of pre-tested procedural rules. They manage the financial deposits, and they oversee the appointment of the arbitrators. They basically act as a safety net to ensure the process keeps moving, even if the other side refuses to cooperate.
Okay, and ad hoc is the opposite. You're just kind of flying blind.
Pretty much. In an ad hoc arbitration, the parties agree to arbitrate, but they don't select an institution to administer it. They might adopt a set of rules like the UN-Zeitfrau rules, but there is no overarching administrative body managing the mechanics.
That sounds risky.
It is, because if the employer simply refuses to appoint their arbitrator, you have to go to the national courts to force an appointment.
Which takes forever, I'm guessing.
It can take months or years. Institutional arbitration is generally far, far safer for complex international construction disputes.
Makes sense. And then we get to the multi-tiered dispute resolution clauses. The sources emphasize that in construction, you almost never just file for arbitration on day one. It's like an escalation process.
Yes. Think of a multi-tier clause like a highly specific mechanical interlock sequence on a heavy turbine.
Okay, I like that analogy.
You physically cannot engage the main arbitration engine until you have flipped the preliminary switches in the exact correct chronological order.
So what does that sequence look like?
The contract might dictate a strict sequence. First, maybe a formal 28-day notice of claim to the engineer. Second, if the engineer's determination is rejected, the parties must engage in good faith negotiations between senior executives for 30 days.
Just to try and hash it out.
Right. Third, if that fails, the dispute goes to a Standing Dispute Adjudication Board, or DAB, for an interim decision. Only after all those steps are exhausted and a formal notice of dissatisfaction is filed, only then can you commence arbitration.
So, on our Meridian Airport project, let's say the employer denies our multi-million-dollar claim for the flooded baggage tunnel. The commercial team is furious, the CEO is screaming about cash flow, and they tell you, just file for arbitration immediately. Bypass the DAB, it's a waste of time. They always side with the employer anyway.
Which is a very common reaction.
Right. But if you follow that order, what actually happens?
The system shuts down.
Completely.
Completely. The employer's legal team will file an immediate jurisdictional objection to the tribunal. They'll argue that the precondition to arbitration, the DIB process, was not fulfilled. And the tribunal, adhering strictly to the contract language, will agree.
Wow.
They will decline jurisdiction. You will have wasted hundreds of thousands of dollars in legal filing fees, only to be sent all the way back to square one to start the DIB process you just tried to skip. You must respect the mechanical interlock of the multi-tier clause.
Okay, let's unpack this, because there is one distinction in the source material regarding the arbitration agreement that absolutely trips up commercial managers.
I think I know what you're going to say.
It's the difference between the seat of arbitration and the physical venue. Because to anyone applying normal project site logic, those sounds like the exact same thing. Like if the meeting is in room 4B, the location is room 4B.
It is the most dangerous point of confusion for a non-lawyer reading an arbitration clause.
Really, the most dangerous.
Oh, absolutely. The venue, or the physical place of the hearings, is nothing more than a logistical convenience. Let's look at our Meridian Airport project. The actual construction site is somewhere in the Middle East.
Okay.
It might be entirely convenient for all the project directors, the factual witnesses, and the tribunal members to physically fly into Dubai, rent a conference room in a 5-star hotel, and conduct the 2-week evidentiary hearing there.
Sure, because it's a major hub.
Right. Dubai, in that scenario, is just the venue.
It's just where the coffee is poured and the microphones are plugged in.
Exactly. But the seat of the arbitration is a profound legal concept. The seat establishes the juridical home of the arbitration.
Juridical home. What does that mean in practice?
It dictates the overarching legal framework that supports, supervises, and ultimately controls the entire private arbitration process.
Let's make this concrete. In the Meridian Airport contract, let's say the clause explicitly states, the seat of the arbitration shall be London, England.
Right.
But we are physically sitting in that hotel conference room in Dubai, arguing about a project built in the Middle East. What does London have to do with anything?
Because the seat is London, the English Arbitration Act of 1996 is invisibly holding up the roof of that conference room in Dubai.
Oh, wow.
The English legal system is providing the procedural scaffolding. This means the English courts have supervisory jurisdiction over your dispute.
But wait, why do we need supervisory jurisdiction? I mean, isn't the whole point of arbitration to get away from national courts?
Well, you want to avoid national courts for the substance of the dispute, yes. You don't want a local judge trying to decipher a complex time impact analysis. But you absolutely need a competent court system to support the integrity of the process. Think about it. What if an arbitrator suddenly resigns halfway through and the parties can't agree on a replacement?
Oh, you'd be stuck.
Exactly. So you apply to the courts at the seat, the English courts, to appoint one. Or, more importantly, what if the tribunal issues a massive award against you, but you discover that the presiding arbitrator took a secret bribe from the employer?
That would be a disaster.
It would. And you cannot just ignore the award. You must affirmatively apply to the courts at the seat to have that award legally set aside or annulled.
So if the seat is London, you go to the High Court in London to annul the corrupt award.
Yeah.
But if you carelessly agree to a seat in a country with a highly corrupt, underdeveloped, or just incredibly slow judicial system, you are essentially trapping your multi-million-dollar dispute inside a broken legal framework, regardless of where the physical hearings take place.
Precisely. Choosing the wrong seat can leave you completely defenseless if the arbitral process breaks down. This is why commercial teams cannot view the seat as just a geographical preference for travel. It is a fundamental risk allocation decision.
Which brings us perfectly to the concept of the traps hidden in these clauses. The source material talks about pathological arbitration clauses.
Yeah.
And that word, pathological, implies like a disease or a fatal flaw.
It is a contractual disease that infects the dispute before it even begins. A pathological clause is an arbitration agreement drafted so poorly with such contradictory, vague, or just legally impossible mechanics that it simply cannot be smoothly operated.
Give me an example of what that looks like on our Meridian Airport project. Let's say during the final chaotic hours of contract negotiation, the employer's procurement team and our commercial team just mashed together a bunch of different boilerplate templates to get the deal signed. What does a pathological clause actually say?
Well, it might read something like this. Any and all disputes shall be finally settled by the International Chamber of Commerce, applying the arbitration rules of the London Court of International Arbitration, to be heard by a single arbitrator appointed by the president of the Swiss courts, with the seat of arbitration being the city of Dubai.
Okay, applying standard construction logic to that, that sounds like a nightmare. You are demanding that the ICC, one specific corporate entity, manage a dispute using the proprietary rulebook of their direct competitor, the LCIA.
It is the equivalent of demanding that a Boeing engineering team assemble an aircraft using purely Airbus instruction manuals while being supervised by a maritime shipping captain.
That is absurd.
It doesn't work. The ICC will likely refuse to administer a case under LCIA rules. The LCIA will refuse because the contract named the ICC. You have created a total deadlock.
And what are the Swiss judge part?
Right. The mechanism for appointing the arbitrator is also flawed. The president of the Swiss courts has no legal obligation to appoint an arbitrator for a private dispute seated in Dubai, and will very likely just ignore the request.
So what happens? Do the courts just look at it and say, well, they clearly meant to arbitrate, let's just fix it for them?
Some highly arbitration-friendly jurisdictions might try to creatively interpret the intent of the parties to save the clause, but in many jurisdictions, that clause is entirely void for uncertainty. And if the arbitration clause is void, where does the dispute go?
Oh, no. It goes straight back to the local national courts of the country where the airport is being built, which is exactly what the international contractor was desperately trying to avoid in the first place.
Exactly. You are essentially fighting an incredibly expensive, multi-year, multi-jurisdictional legal battle about the dispute resolution mechanism before the tribunal even gets to look at a single piece of evidence regarding the flooded baggage tunnel. If the answer to who appoints the tribunal and what rules apply is unclear, you have built your arbitration strategy on a cracked foundation.
And this ties directly into the concept of tribunal jurisdiction. As a commercial manager transitioning into this space, you have to compartmentalize two very distinct questions when a dispute erupts.
Yes, you must rigorously separate jurisdiction from substance.
Okay, lay them out.
The jurisdictional question is, does this specific panel of 3 arbitrators have the legal authority granted by a valid agreement and the fulfillment of all multi-tier preconditions to hear the specific dispute? The substantive question is, based on the evidence in the contract, is the contractor actually entitled to $50 million for the bedrock delay?
And the brutal reality is that those two questions are entirely independent. You can have the greatest, most irrefutable delay claim in the history of civil engineering. You can have perfect video evidence of the tunnel flooding, perfect cost records, flawless schedules. But if the tribunal lacks jurisdiction because of a pathological clause or a missed precondition,
your brilliant substantive claim is worthless.
Really, just worthless.
The tribunal will issue an award declining jurisdiction, order you to pay the employer's legal costs for the jurisdictional phase, and pack up their briefcases.
It is the ultimate procedural guillotine. This is why securing the perimeter, ensuring the tribunal's jurisdiction is unassailable, is the absolute first priority before you spend a single dollar on technical experts.
Could not agree more.
So let's assume we survive the contract drafting phase. We have a valid, well-drafted ICC arbitration clause. We filed our notices on time. We climbed the multi-tier ladder perfectly. The tribunal is constituted, and jurisdiction is secure.
Good perimeter is locked.
Right. The next question we face on the Meridian Airport dispute is, what rules are we actually playing by inside the room? Because looking at the syllabus, international construction arbitration is never as simple as just opening up a single local rulebook.
No, it is a highly complex, multi-layered matrix of different legal systems operating simultaneously. This is where construction professionals can experience intense vertigo.
I can imagine.
You are suddenly dealing with a web of laws that govern different aspects of the exact same dispute.
Here's where it gets really interesting. Because if you look at the breakdown in the sources, you don't just have one law. You have the law governing the substantive construction contract. You have the law governing the arbitration agreement itself, which can actually be different from the main contract.
Yes, that trips a lot of people up.
And you have the procedural law of the arbitration, which we establish is tied to the seat. You have the mandatory laws of the project location regarding things like health and safety or environmental regulations. And eventually you have the laws of the country where you actually want to enforce the award.
It sounds overwhelming, I know. But the goal here is not for a quantity surveyor or a commercial director to suddenly qualify as a multi-jurisdictional lawyer.
Thank goodness.
The goal is issue spotting. You must understand the fundamental difference in how these laws interact, specifically the critical boundary between substantive law and procedural law, because confusing the two will absolutely derail your case strategy.
Let's break that boundary down using the Meridian Airport baggage tunnel. Let's say the substantive law governing the contract, clause 1.4 of the FIDA conditions, states that the contract shall be governed by the laws of the United Arab Emirates, because the project is in the Middle East.
Okay.
But, as we established earlier, the seat of the arbitration is London, meaning the procedural law is the English Arbitration Act. How does that tension play out in reality?
It dictates exactly how you build your arguments. The substantive law, the UAE Civil Code in this hypothetical, is what determines your actual legal rights and obligations under the contract. It determines the meat of the argument.
Example.
Well, civil law systems like the UAE have a deeply embedded concept of good faith in the performance of contracts. They also grant judges and arbitrators the power to adjust pre-agreed liquidated damages if they are wildly disproportionate to the actual loss suffered.
So if the employer's hitting us with massive delay damages for the baggage tunnel, our substantive defense relies on UAE law principles to argue those damages should be reduced.
Exactly, that is a substantive defense. But the procedural law, English law, because London is the seat, dictates how you are allowed to present that defense to the tribunal.
Okay, give me an example of the procedural side.
English procedural law will govern whether you are allowed to demand the employer's internal financial records through document disclosure. It governs whether the tribunal has the power to order the employer to put up security for costs. It governs the rules around cross-examining witnesses.
So, substantive law is what you are fighting about. Procedural law is how you are allowed to fight.
That's the perfect way to summarize it.
And the rule book for that fight isn't just a generic statute. The sources heavily emphasize the reliance on procedural directions in case management conferences. In arbitration, it seems like the tribunal essentially writes a bespoke rule book for your specific dispute.
That is one of the massive advantages of arbitration. The procedure is flexible and tailored. Shortly after the tribunal is appointed, they will hold a case management conference, usually virtually, with the legal and commercial teams from both sides.
What are they deciding in that conference?
They will look at the complexity of the Meridian Airport tunnel dispute and ask, how much time do we need? Do we need to bifurcate the proceedings?
Meaning what?
Meaning, do we try the jurisdictional or liability issues first before spending millions calculating the exact quantum? How many rounds of written pleadings are necessary? How will we handle expert evidence?
And the output of that conference is the procedural order number 1.
Yes, PO1. It is the architectural blueprint for the entire arbitration timeline.
So it's basically the schedule.
Exactly. It establishes the procedural timetable. It sets the exact calendar dates for the statement of claim, the statement of defense, the exchange of document requests, the submission of factual witness statements, the exchange of expert delay and quantum reports, and ultimately, the dates for the final evidentiary hearing.
I want to push back on the reality of these deadlines, though. On a massive construction site, internal deadlines are constantly shifting. If the commercial team is supposed to issue a monthly cost report on Friday, but the project control software crashes, they submit it on Tuesday. Everyone grumbles, but the project moves on.
Right, that's just construction reality.
Exactly. A site instruction to revise a drawing might sit on a desk for a week. There's a culture of fluid deadlines because the physical work takes precedence. What happens if a commercial team brings that fluid, site-level mentality to an arbitration procedural timetable? Let's say our delay expert needs just a few more days to perfect our time impact analysis model, so we miss the Friday deadline and submit the report the following Wednesday.
Bringing project site fluidity to an arbitration timetable is a recipe for absolute disaster.
Really? Over a few days?
The consequences are binary and severe. Due process in arbitration requires that both parties have an equal opportunity to present their case and respond to the other side. If you submit a highly complex delay report 5 days late, you have prejudiced the employer's ability to analyze it and respond within their allotted time frame.
So the employer's lawyers complain to the tribunal. What does the tribunal actually do?
The tribunal has the discretionary power to simply strike that evidence from the record. They can issue an order stating, the claimant's expert delay report filed out of time in breach of procedural order number 1 is inadmissible.
Just like that. The expert report that caused $250,000 to produce, the entire technical basis for why the baggage tunnel was delayed, is just gone.
Gone. The tribunal will not look at it. The opposing side does not have to respond to it.
That is insane.
Missing a procedural deadline in arbitration is not a minor administrative slip. It can literally be fatal to the entire case. This is why the transition requires immense procedural discipline. You must treat the procedural timetable with the same gravity as a concrete pour. Once it is set, it cannot be altered without formal prior permission from the tribunal.
That is a terrifying level of rigidity, but it forces a discipline that is absolutely necessary when millions are on the line. So let's take stock. We have lockdown jurisdiction. We understand the web of substantive and procedural laws. We have our bespoke procedural order number 1, and we are treating those deadlines as absolute law.
Those are so good.
Now we move to the actual core of the dispute itself, the substantive claim. And this is where the listener, the quantity surveyor, the contract engineer, finally gets to wield their massive home field advantage, because everything in the substantive case is anchored to the construction contract.
This is the exact moment where the commercial team becomes the most valuable asset in the room. You can hire the most brilliant international arbitration lawyers in the world, but they do not instinctively understand how a bill of quantities operates.
Right. They're lawyers, not engineers.
Exactly. They do not intuitively grasp the interplay between employers' requirements, contractors' proposals, and design variation mechanisms. A construction arbitrator cannot decide a case without forensically unpacking the contract documents, and the project team are the native speakers of that language.
The syllabus specifically points to mastering standard forms, like the FIDIC rulebook, understanding payment provisions, variation clauses, and particularly the extension of time, or EOT, mechanisms. Because at the end of the day, almost every construction arbitration boils down to 2 things: time and money.
Time and money, and fundamentally risk allocation.
Risk allocation, how so?
The contract is simply a manual detailing which party agreed to bear the financial risk of specific unknown events. Who bears the risk of exceptionally adverse weather? Who bears the risk of uncharted underground utilities? Who bears the risk of changes in local legislation?
Let's apply this to the Meridian Airport. We are digging the underground baggage handling tunnel. The geotechnical baseline report provided by the employer during tender showed standard, easily excavatable clay. But 3 months into the dig, our tunnel boring machine hits a massive, undocumented, highly abrasive subterranean rock formation that is saturated with high-pressure groundwater.
Ouch.
The tunnel floods. The machine is severely damaged. The entire critical path of the airport terminal is pushed back by 6 months, and we are burning $100,000 a day in overhead and standby costs.
A total disaster.
The commercial team wants to walk into arbitration, show the tribunal the photographs of the flooded tunnel, show the baseline report, show the invoices, and demand $20 million.
And if they do exactly that, they will lose entirely.
Wait, really? But it's so obvious.
Showing a bad event and demanding money is project-level complaining. It is not an arbitral claim. The tribunal cannot award money simply because something unfortunate happened and the contractor lost money. A successful claim in arbitration requires a highly structured, unbreakable logical architecture. It is known as the chain of a claim.
Looking at the structure outlined in the materials, this chain has 6 distinct links. You can't just skip from the flooding to the money. Let's build the chain for the Meridian Airport tunnel.
Let's do it. We build it link by link. Link 1 is the event.
Okay, the event.
What physically and factually occurred. In our case, the TBM encountered an undocumented, saturated rock formation resulting in a flood. That is the factual foundation.
Okay, establishing the event seems straightforward. We have photos and site diaries. What is link 2?
Link 2 is contractual entitlement. You must point to the specific clause in the FIDIC contract that shifts the financial risk of that specific event from the contractor to the employer.
So you can't just say it's unfair.
You cannot just say it's unfair. You must assert, for example, that under FIDIC subclause 4.12, this constitutes an unforeseeable physical condition. You must legally define why it was unforeseeable by an experienced contractor at the time of tender.
Right. If you don't have entitlement, the event is just your bad luck. Okay, link 3 is causation.
Causation is the connective tissue. Did that specific unforeseeable physical condition actually cause the problem you are complaining about?
Meaning what?
Well, it is entirely possible that the tunnel flooded on Tuesday, but your TBM was already broken down on Monday due to a lack of basic maintenance.
I see.
If the employer can prove your machine was already down, the bedrock event didn't cause the delay. You must prove the event was the operative cause of the impact.
Let's assume we prove causation. The rock caused the stoppage. Link 4 is delay or loss.
Yes. What was the exact physical and temporal impact? Did this stoppage just consume available float in the schedule, or did it push the final completion date of the entire airport? You must definitively prove that the critical path was extended by, say, exactly 43 days.
Link 5 brings in the accountants. Quantum.
Quantum is the exact financial translation of that delay and disruption. If the project was delayed by 43 critical days, what is the precise auditable cost of the extended site overheads, the extended crane rentals, the idle labor? You must prove the actual costs incurred, stripped of any inefficiencies that were your own fault.
And finally, Link 6 is relief.
Yeah.
What are you formally asking the tribunal to do? Grant a 43-day extension of time, relieve the contractor of delay liquidated damages, and award $15 million in prolonged costs, plus interest and legal fees.
Exactly.
Event, entitlement, causation, delay, quantum, relief.
That is the complete chain.
But I want to explore the vulnerability of this architecture. What happens if you have an incredibly strong chain? You have perfect evidence of the bedrock, you have unassailable quantum calculations, your delay model is flawless, but just one single link is missing.
A single link.
Yeah. Let's go back to link 2, entitlement. Let's say in the chaos of dealing with the flooded tunnel, prioritizing safety and engineering solutions, the commercial manager completely forgot to send the formal 28-day notice of claim required under FID subclause 20.1.
Oh boy.
The employer knew about the flood, they were standing right there on site watching it happen, but the formal piece of paper wasn't sent until month 3. Does that multi-million-dollar chain survive?
In many common law jurisdictions, and increasingly in civil law jurisdictions, depending on the exact drafting, that single missing link destroys the entire chain.
Wait, destroys it completely?
Yes. If the notice provision is drafted as a condition precedent, meaning the contract expressly states that if notice is not given within 28 days, the employer is discharged from all liability. The tribunal's hands are often legally tied.
Even though the employer suffered no prejudice because they literally watched the tunnel flood.
Even then. The legal principle is that the parties freely agreed to a strict risk allocation mechanism. The contractor failed to operate the mechanism, therefore the contractual entitlement evaporates.
That is brutal.
You proved the event, you proved the cost, but you failed on entitlement. The $15 million claim fails entirely solely because of project administration failure.
That is agonizing. But it reinforces the overarching mission.
Mm-hmm.
You have to view the claim holistically. You cannot isolate the engineering reality from the contract administration. This leads directly to how we actually present this massive narrative to the tribunal. Because you can't just hand them a 10,000-page hard drive of correspondence and say, you know, the chain is in there, figure it out.
Definitely not.
The source material heavily emphasizes building a chronology.
A well-constructed chronology is arguably the single most persuasive, foundational tool in a complex construction arbitration. A major dispute like the Meridian Airport might involve 2 million contemporaneous documents.
2 million.
Easily. Emails, WhatsApp messages, site instructions, meeting minutes, drawings. The 3 arbitrators do not have the time, the budget, or the capability to organically reconstruct the narrative arc of a 4-year mega project from a scattered pile of PDFs.
You have to process the raw data for them. You have to map it out.
Precisely. You build a chronological spreadsheet that forces the tribunal to see the project exactly as you see it.
What does that spreadsheet look like?
Column 1 is the date. Column 2, the factual event. Column 3, the contractual significance of that event. Column 4, the specific evidence cross-reference. Column 5, the consequence.
So instead of just dumping emails, it looks like this. March 15th, event. TBM encounters uncharted bedrock and floods. Contractual significance. Unforeseeable physical condition under clause 4.12 triggering notice requirement. Evidence. Daily site diary, #142, and formal notice letter, #88. Consequence. Excavation halted, critical path impacted.
Yes. You draw a straight, undeniable line from the fact, to the contract, to the proof. When the tribunal sits down to write their final award, a masterful chronology acts as their roadmap.
And if you don't do that?
If your chronology is weak, chaotic, or skips over bad facts, the tribunal will discard it and rely on the employer's chronology, which will frame you as an incompetent contractor who caused their own delays.
Which brings us to the next massive phase of our deep dive. A perfectly structured chronological chain is nothing but a nice, highly creative work of fiction, unless you can actually prove that every single entry on that spreadsheet is undeniably true. We are transitioning to the ammunition required for this battle, the evidence.
And this transition represents perhaps the biggest culture shock for commercial managers moving from project administration into arbitration. The absolute difference between an assertion and evidence.
Right. During the active construction phase, you sit in a monthly progress meeting. The commercial manager pounds the table and declares the employer is delaying the entire terminal because the architectural team is taking 6 weeks to turn around the ceiling grid submittals instead of the required 2 weeks.
A very common occurrence.
Everyone in the room, the engineer, the employer's rep, nods and generally agrees because they all know intuitively that it's happening. The assertion is accepted as reality.
But in the arbitration hearing room, 3 years later, the tribunal was not at that meeting. They have no intuition about your project.
They weren't there.
Exactly. They will look at that commercial manager's witness statement making that assertion, and they will say, that is an interesting theory, now prove it. They demand forensic specificity.
They want the receipts.
Exactly. Which specific submittals were late? When were they submitted? When were they returned? What was the exact contractual turnaround time? Did those specific submittals actually hold up critical procurement, or were they just background noise?
Right. You need the paper trail.
What specific contemporaneous records, requests for information, transmittals, procurement logs demonstrate this causal link?
Factual evidence is king. Daily site reports, meeting minutes, payment certificates, native scheduling files, timesheets, procurement records, progress photographs. But here is the major strategic hurdle we face on the Meridian Airport project.
Okay, lay it on me.
Let's go back to our flooded baggage tunnel. We need to prove under Clause 4.12 that the bedrock was unforeseeable. We have a strong suspicion that the employer's initial geotechnical consultants actually did find the high-pressure water and bedrock during tender, but the employer deliberately hid that internal report to keep the tender prices low.
That happens more often than you'd think.
We don't have that report. It's sitting on the employer's servers. How do we get it?
This is where document production strategy becomes critical, specifically governed by international frameworks like the IBA rules on the taking of evidence in international arbitration. Gathering evidence isn't just about indexing your own files. It is about surgically extracting the hidden ammunition from your opponent.
The source material highlights a specific tool for this called a Redfern schedule. Honestly, when I first heard the phrase Redfern schedule, I pictured a complex railway timetable for shipping materials. But it is actually a highly structured weapon for compelling document disclosure.
Right. It is the standard strategic tool for document production in international arbitration. A Redfern schedule is a table containing specific columns designed to force both the requesting party and the tribunal to rigorously evaluate the need for documents.
How does it work?
Column 1 is the specific document or narrow category of documents requested. Column 2 is the requesting party's justification. Why is this document relevant to the case, and why is it material to its outcome?
Okay, so you have to explain why you want it.
Right. Column 3 is for the opposing party to state their objections, for example, arguing the documents are privileged or too burdensome to find. And the final column is left blank for the tribunal to make its binding decision to order production or deny the request.
If I'm the commercial director and I'm furious about this hidden geotechnical report, my instinct is to use the Redfern schedule to ask for all internal emails, draft reports, and communications sent or received by the employer's project management and engineering teams regarding the ground conditions of the baggage tunnel from the beginning of time until today.
Of course, that's what everyone wants to ask for.
Just dump their servers onto a hard drive and we will find the smoking gun.
This raises an important question. What proposition are you actually trying to prove? Because what you just described is known as a fishing expedition, and international arbitral tribunals absolutely loathe it.
Really? They would just let you look.
In international arbitration, unlike the sprawling, incredibly expensive discovery process you might see in domestic U.S. litigation, you do not get broad, sweeping access to the other side's files. You cannot ask for everything regarding the tunnel.
Oh, wow.
If you submit a Redfern request drafted like that, the employer will object on the grounds of unreasonable burden, and the tribunal will instantly deny your request. You get nothing.
So it's more like a surgeon's scalpel rather than a bulldozer. You aren't just clearing the entire digital site. You have to make a highly specific, calculated incision to extract the exact organ you need.
That is the perfect analogy. You must be surgical. You look at your chronology. You identify the exact contested issue. Was the bedrock foreseeable based on pretender surveys? And you tailor the request precisely to that issue.
What should the request look like then?
Instead of all emails, your red fern request should read. Final and draft versions of the geotechnical baseline risk assessment reports produced by Consultant X for the employer between January 1st and March 30th regarding the baggage tunnel alignment.
Because that request is bounded by time, it identifies specific actors, and it ties directly to a material issue in dispute.
Exactly. The tribunal looks at that surgical request, recognizes that it is highly relevant to determining the unforeseeability test under Clause 4.12, and notes that it is not overly burdensome for the employer to locate a specific report from a specific consultant.
And then
The tribunal strikes their gavel in the final column. Request granted. The employer is legally compelled to hand over the hidden report.
okay, so we've used our scalpel. The employer turns over the hidden geotechnical report proving they knew about the water. We also have a mountain of our own evidence. Thousands of daily reports, timesheets, and massive, complex, native Primavera P6 scheduling files detailing the delays.
Which is a lot of data.
It is. But here's the reality of the hearing room. Raw data and P6 schedules do not speak for themselves. You cannot just hand a massive hard drive of data to 3 arbitrators who might be brilliant lawyers but have never poured concrete in their lives and expect them to organically calculate the critical path delay.
No, they will drown in the data. This is where we bring in the interpreters,
The witnesses.
the witnesses of fact, and the independent expert witnesses. And here, a construction professional managing an arbitration must rigorously enforce a very strict legal boundary, the difference between fact and opinion.
Let's break that boundary down because on a construction site, fact and opinion are constantly blended together.
They are blended on site, but they must be surgically separated in the hearing room. Let's use our project manager for the baggage tunnel. We put him on the stand as a factual witness. He can establish facts based on his direct contemporaneous perception. He can say, on March 15th, I physically saw water flooding the tunnel at a rate of 500 liters a minute. On March 16th, I issued an instruction to halt the TBM. Those are facts. They happened.
Right, he was there, he saw it, he did it.
But if the project manager writes in his witness statement, the flooding of the tunnel on March 15th delayed the critical path of the entire airport terminal completion by precisely 43 days, overriding the concurrent delay of the employer's late ceiling design, that crosses a massive legal line.
Because that isn't a direct observation. That requires complex schedule analysis.
Exactly. It is an opinion. Specifically, it is an expert opinion that requires complex forensic methodology. A factual witness, even a highly experienced project manager, is generally not permitted by the tribunal to give expert opinion evidence on complex causation and critical path delay.
Wait, really? Even if they've been doing it for 30 years?
Even then, if you rely on your project manager to prove the 43 days, the employer's lawyers will tear his testimony apart on cross-examination. The tribunal will disregard his conclusions, and you will fail to prove link 4 of the chain, delay.
So to bridge that gap, to take the factual data of the flood and legally transform it into a proven 43-day critical path delay, we must bring in an independent delay expert.
Precisely. The delay expert's mandate is to establish delay and causation using globally recognized forensic scheduling methodologies. The syllabus lists several of the primary techniques: as planned versus as built, impacted as planned, time impact analysis, and time slice analysis.
Do our commercial managers and QS teams need to become experts in running all these complex P6 software algorithms themselves? Do they need to know how to calculate float degradation mathematically?
No, the commercial team's job is not to run the software. The crucial skill for a construction professional managing the arbitration is understanding the strategic mechanics of these methods, and more importantly, understanding why a specific method must be matched to the actual reality of the project records.
Meaning?
If you choose the wrong methodology for your records, the expert's report will collapse.
Let's dive into those mechanics. Give me a real-world application on the Meridian Airport. How does a time impact analysis, a TIA, actually work?
A time impact analysis is an incredibly powerful, forward-looking methodology. It asks, what was the projected impact of the event at the exact moment it occurred? To run a TIA, the expert needs perfect data.
Okay, perfect data.
They take the accepted baseline Primavera P6 schedule. They update it with actual progress up to March 14th, the day before the flood. Then they build a fragmentary network of new schedule activities representing the bedrock and the flooding delay. They surgically insert this fragment into the schedule on March 15th.
And then they hit F9 in the software to recalculate the schedule.
Exactly. The software recalculates the logic links, pushes the activities forward, and the expert observes exactly how that specific inserted event moved the final completion date of the airport. It is highly persuasive because it isolates the event in time.
But wait, that assumes we have a perfect, logic-linked, fully updated baseline schedule for March 14th. What if the Meridian Airport project was absolute chaos?
It often is.
Right. What if the baseline schedule was never officially approved by the employer? What if the planning engineers were terrible, the monthly updates were garbage, the logic links were broken, and the schedule showed the roof being installed before the foundation was poured?
If the underlying scheduling data is trash, a time impact analysis becomes a multi-million-dollar work of science fiction.
Science fiction, I like that.
The expert would be inserting a delay event into a model that does not reflect reality. The tribunal will see right through it. In that chaotic scenario, the expert cannot use a forward-looking model. They must use a retrospective methodology, like a collapsed as-built analysis.
How does that work mechanically?
It works in reverse. The expert ignores the flawed baseline entirely. They look at the very end of the project. They take the final actual as-built schedule, which is a factual record of when everything was actually built. Then they identify the delay events caused by the employer, like the bedrock flood. They surgically remove those employer delays from the final schedule and mathematically collapse the logic backward to determine when the contractor would have finished the project if the employer hadn't caused those problems.
That is fascinating. So the expert's primary job is to look at the health of the project data and select the weapon that actually fires correctly. And once the delay expert figures out the precise mathematical time impact, proving our 43 days, we then need someone to figure out the exact cost of those 43 days. We need the quantum expert.
Yes, and just like the delay expert, the quantum expert must rigorously connect the financial numbers to causation. A claim for $15 million doesn't become recoverable simply because the spreadsheet arithmetic adds up correctly and is signed by an accountant.
Right. You can't just walk in, drop your audited corporate tax returns on the desk, and say, look, we lost $15 million on this airport. Give it back.
Exactly, because the tribunal will say, perhaps you lost that $15 million because you deliberately underbid the tender to win the job. Perhaps your concrete subcontractor was incredibly inefficient. Why should the employer pay for your bad commercial decisions?
Right.
The quantum expert has to connect the cost logically and exclusively to the employer's risk event.
Walk me through the mechanics of that quantum connection for our flooded tunnel.
It follows a strict logical path. We start with the established causation. The unforeseeable bedrock, which is employer risk, caused a 43-day critical path delay. The quantum expert then calculates the precise cost of remaining on site for those 43 extended days.
Like what?
They calculate the prolonged site, overheads the cost of keeping the project director's trailer running, the security guards, the extended rental cost of the tower cranes that couldn't be dismantled.
What about the head office? The corporate headquarters in London or Dubai is still burning cash to support a delayed project.
That is unabsorbed head office overhead, and it is a massive battlefield in arbitration. The quantum expert will deploy complex accounting formulas like the Eichle formula or the Emden formula to mathematically demonstrate how the delay on the Meridian Airport prevented the contractor from taking on new work, thereby depriving the corporate head office of the revenue contribution it expected.
Wow, so it gets really deep into the accounting.
Oh, absolutely. They also assess complex claims for a loss of labor productivity and disruption, which are notoriously difficult to prove without immaculate timesheet data.
Now, regarding these independent experts, the delay analysts and the quantum accounts, there is a crucial dynamic that commercial teams often misunderstand. The contractor is the one selecting these experts. The contractor is paying their massive invoices.
Yes.
So there is this natural project-level assumption that the expert is basically a highly paid mercenary.
Yeah.
A hired gun whose job is to aggressively argue the contractor's case and hide any bad facts.
That assumption is not only legally incorrect, it is strategically suicidal in international arbitration. The fundamental rule, codified in various protocols, is that an independent expert is not an advocate for the party that appoints them and pays their bills.
Their duty isn't to the contractor.
Their overriding primary duty is to assist the arbitral tribunal in understanding technical matters within their specialized field. They must be completely impartial and objective.
Okay, give me an example of how that plays out.
Let's say your delay expert is running the time impact analysis, and they discover that during the exact same week the tunnel flooded, your concrete subcontractor completely abandoned the site. That is a concurrent contractor delay.
Right, which looks bad for us.
If the expert acts like a hired gun and deliberately hides that concrete delay to make the contractor look better, what happens during the hearing?
The employer's expert, who has access to the exact same schedules, will expose the omission during cross-examination.
Exactly. The employer's barrister will cross-examine your expert, expose the deliberate manipulation of the model, and in that instant, your expert's credibility drops to absolute zero.
Just like that.
Yes. The tribunal will completely discount their entire report. You just paid $500,000 to destroy your own case. A good expert must state their objective opinion, even if it hurts the party paying them.
That's a hard pill to swallow for the commercial team.
It is. But if the quantum expert believes only 10 million of the 15 million is truly provable, they must state 10 million. That independence is what makes their evidence persuasive to the tribunal.
And that standard of absolute independence brings up the arbitrators themselves. The syllabus touches on arbitrator impartiality and the IBA guidelines on conflicts of interest. Because many senior construction professionals, the commercial directors listening to this, eventually aspire to transition to the other side of the table and sit as arbitrators. But the rules emphasize that technical brilliance alone isn't enough.
Having immense technical expertise knowing every single subclause of the FIDIC Red Book, or understanding the exact engineering tolerances of a tunnel boring machine, is highly valuable, but it does not automatically make you a good arbitrator.
What does then?
An arbitrator must possess judicial temperament. They must maintain absolute procedural discipline, ensuring due process and equal treatment of the parties, and critically, they must be completely free of justifiable doubts regarding their independence.
They can't have a hidden financial interest in the employer's parent company, or have recently acted as a consultant for the contractor's legal team. They are no longer project problem solvers. They are private judges dispensing binding justice.
Precisely. They are managing a highly rigid legal process. So let us take stock of the architecture we have built for the Meridian Airport dispute.
Let's review the fortress. The perimeter is secure. Jurisdiction is established, and the pathological traps were avoided. The rules of engagement are set. We understand the tension between the UAE substantive law and the English procedural law, and we are rigorously obeying the procedural timetable. The substantive claim is chained together: event, entitlement, causation, delay, quantum. The evidence has been surgically extracted using a targeted Redfern schedule. And our independent delay and quantum experts have translated the raw project data into objective, persuasive methodologies.
We have all the raw materials of victory. Now we arrive at the climax of the entire arbitral process.
Okay.
How does a commercial and legal team package this massive, sprawling universe of engineering data, legal theory, and financial modeling into a final binding presentation that actually forces the tribunal to award the money?
This brings us to the architecture of the formal presentation, the pleadings, and ultimately the award. The syllabus lists documents like the request for arbitration, the statement of claim, and the statement of defense. To a commercial manager used to writing aggressive two-page letters to the engineer, what does a formal statement of claim actually look like? It isn't just a very long, angry letter, is it?
Far from it. A well-crafted statement of claim is a masterpiece of logical organization and legal prose. It is the definitive narrative map that you hand to the tribunal. It does not just dump facts and data. It synthesizes the entire case.
So what's in it for our baggage tunnel dispute?
A strong statement of claim for our baggage tunnel will methodically walk the tribunal through the chronology. It will clearly state the factual background of the bedrock discovery. It will identify the specific FIDI clause 4.10.
The entitlement link.
Exactly. It will legally argue why the bedrock was unforeseeable under UAE law. It will insert the findings of the delay expert regarding the 43 days. It will detail the quantum expert's calculation of the $15 million, and it will precisely cross-reference every single assertion to a specific tab in the evidentiary bundles and witness statements.
It is the ultimate manifestation of the chain of a claim. Every single link is explicitly laid out and heavily armored with evidence.
Exactly. And the employer's statement of defense will attempt to systematically shatter every single link in that chain.
How do they do that?
They will argue the bedrock was foreseeable based on the tender site visit. They will argue the notice was late. They will attack the delay expert's methodology as flawed. They will argue the unabsorbed overhead calculations are speculative. It is a highly structured, formal battle of narratives.
And after all the written pleadings are filed, after the intense multi-week evidentiary hearings in that Dubai conference room, after the factual witnesses have been grilled and the experts have engaged in intense cross-examination, the tribunal finally closes the proceedings.
The heavy lifting is done.
They retreat to deliberate and write the final document. the arbitral award. The source material frequently refers to a reasoned enforceable award. What does the anatomy of that document look like? Do they just issue a one-page letter saying, "We agree with the contractor, employer must pay $15 million"?
No. In international commercial arbitration, tribunals are almost always required to issue a fully reasoned award. This is a highly disciplined, often massive document, sometimes hundreds of pages long.
Hundreds of pages.
Yes. The tribunal must explicitly explain the mathematical and legal reasoning behind their decision to a standard that can withstand intense scrutiny by a national court. They have to show their work.
What is the structure of that reasoning?
It generally follows a deeply logical progression. First, the tribunal outlines the procedural history proving they respected due process. Second, they define the exact issues submitted by the parties for determination.
Okay, setting the stage.
Third, they establish their findings of fact based purely on the admitted evidence. Did the tunnel flood on March 15th? Yes. Fourth, they identify the applicable law, the UAE Civil Code, and the FIDIC contract.
And then the analysis.
Fifth is the crucial analysis section, where they apply the law to the facts. They explain exactly why they preferred your delay expert's TIA over the employer's model. And finally, the dispositive section. The final binding decision, the precise monetary relief granted, and the allocation of the massive legal and arbitral costs.
So what does this all mean? Let's bring this entire massive intellectual exercise back to the ultimate gritty commercial reality for the construction professionals listening.
It all comes down to reality.
Because you can survive the pathological clauses, you can perfectly execute the time impact analysis, you can endure the cross-examination, and you can receive a beautifully written, perfectly reasoned 200-page arbitral award sitting on your desk, is that you win $15 million. But winning the intellectual legal argument is completely, utterly useless if you cannot actually collect the cash and put it back into your company's bank account.
If we connect this to the bigger picture, enforcement is the entire point of the exercise. An arbitral award is ultimately just a stack of paper with 3 signatures on it.
Right.
A private arbitral tribunal does not have a police force. They do not have the power to seize assets or freeze bank accounts. If the employer simply looks at the award, laughs, and refuses to pay the $15 million, the tribunal cannot force them.
So what do?
You must turn to a state's sovereign legal apparatus to enforce the paper. And this is where the absolute greatest triumph of international arbitration comes into play, driven by an international treaty called the New York Convention.
The New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. That is the grand title.
Yeah.
Explain the mechanics of this. Why is this treaty the magic key?
It is arguably the most successful and powerful treaty in international commercial law. It has over 170 signatory countries globally. What it establishes is a unified, relatively seamless system for moving an arbitral award across borders.
Give me the Meridian Airport example.
Let's look at our case. The seat of our arbitration was London. Therefore, the resulting award is legally considered an English award. But let's say the employer's parent company is actually headquartered in Singapore, and their primary corporate bank accounts and assets are located there.
So you have an English piece of paper, but the money is in Singapore.
Precisely. Under the New York Convention, you take that English award to the High Court in Singapore. Because both the UK and Singapore are signatories to the treaty, the Singaporean courts are bound by international law to recognize that English arbitral award and enforce it almost exactly as if it were a domestic judgment issued by their own Singaporean judges.
Meaning the Singapore courts will unleash their state power. They will issue orders to freeze the employer's local bank accounts, seize their corporate assets, or even legally impound a cargo ship owned by the employer sitting in the port of Singapore, and force the sale of those assets to pay your $15 million.
Yes. The state power is activated by the treaty. And critically, the New York Convention heavily restricts the employer's ability to fight back at the enforcement stage. There are very limited, exhaustive grounds on which the Singapore court can refuse enforcement, for example, if the employer can prove they weren't given proper notice of the arbitration, or if the original arbitration clause was proven legally invalid.
But they cannot re-argue the bedrock delay.
Absolutely not. The Singapore judge will not reopen the factual merits of the construction delay. They will not look at the time impact analysis. They will look at the procedural integrity of the award. And if it passes the narrow tests of the convention, they enforce the debt.
So bringing it all the way back to the commercial manager's strategy on day one of the project, your ultimate strategy cannot merely be, can our experts win the intellectual argument in front of the tribunal? The real practical question that dictates everything is, Can this specific arbitral award be effectively enforced under the New York Convention in this specific jurisdiction where the opposing party actually keeps their vulnerable assets?
Precisely. Enforcement strategy must dictate the process from the very beginning. You are reverse engineering the entire multi-year arbitration to ensure that the final piece of paper will be recognized as a lethal instrument by a judge in a completely different country.
That is incredible. It really is a complete holistic life cycle. We are coming to the end of our deep dive today, and I want to recap the massive journey we have taken the listener on. Because the transition from the dirt of the project site to the high-stakes chess match of the arbitration room is profound.
It is a journey of synthesizing distinct layers of capability. As the sources map out, contract knowledge gives you the fundamental architecture.
Because you have to know precisely where the risk was allocated in the FIDIC clauses before you can ask for a dollar.
Claims knowledge gives you the substantive structure.
Forging the unbreakable chain from the factual event through entitlement and causation, all the way to quantum.
Evidence gives you the proof.
Moving away from the project site culture of "I assert this is true" to the forensic reality of the Red Fern schedule extracted the documents that objectively establish this is true.
Arbitration procedure gives you the framework.
Respecting the immense legal power of the seat, avoiding the pathological traps, and adhering rigidly to the unforgiving timetable of the procedural orders.
Reason analysis gives you credibility.
Deploying independent delay and quantum experts to translate raw schedule data into persuasive, impartial methodologies.
And finally, sound award writing, heavily supported by the enforcement power of the New York Convention, gives the dispute its ultimate commercial resolution.
You do not abandon your engineering background, your surveying precision, or your project controls expertise. You take that deep, tactile knowledge of how complex things are actually built, and you construct an impenetrable arbitration fortress on top of it. It requires a new language, but the core logic remains the same.
It is a highly specialized skill set, but for construction professionals, it is entirely attainable because they already inherently understand the underlying physical DNA of the dispute. The law is just the wrapper.
Which brings us back to where we started. That image of the solid, cured concrete foundation versus the murky legal landscape. We've cleared up the murkiness today. We've shown how the legal framework has its own architecture, its own load-bearing walls, and its own unforgiving rules of physics. But I want to leave you, the listener, with one final, slightly provocative thought to mull over as you head back to your projects.
I think I know where you're going with this.
Think about the immense, colossal effort we just described over the last hour. A meticulously calculated, multi-million-dollar quantum report analyzing unabsorbed head office overhead. A flawless, surgically precise time impact analysis inserting a bedrock fragment into a native Primavera baseline. Hundreds of thousands of dollars spent on international legal counsel, months of grueling cross-examination in a Dubai hotel.
So much effort and money.
Exactly. And yet, as we established in segment 1, that entire massive universe of technical and legal effort can be rendered completely legally worthless, struck down on day one by a poorly drafted pathological arbitration clause that failed to specify a functional appointing authority.
The cracked foundation destroys the skyscraper.
Exactly. So the question you have to ask yourself the next time a massive new infrastructure project lands on your desk for signature is this. Are you, as a commercial director, essentially betting the entire financial survival of your company and the outcome of a future $15 million bedrock dispute on a few lines of boilerplate legal text buried at the very back of the general conditions? Text that, if we are being brutally honest, the commercial team rarely bothers to read deeply before the ink dries. Because after today, you know exactly how dangerous that bet can be. The arbitration is won or lost long before the tunnel floods.
A sobering but absolutely essential final thought for anyone managing project risk.
Thank you for joining us on this deep dive. We'll catch you on the next one.